The halls of justice stood tall and imposing, yet within the courtroom of the Honorable Judge Judy Justice, there was a sense of profound clarity and human truth. The air was thick with the stories of lives once intertwined, now seeking resolution under the watchful eye of a woman who had seen the full spectrum of the human heart. On this particular day, the heavy mahogany doors swung open to welcome the first participants of a drama born from the ashes of marriage. The bailiff called the court to order with a voice that commanded immediate respect. All present rose as the judge entered, her black robe flowing behind her like a mantle of wisdom. She took her seat and looked down at the documents before her, her sharp eyes scanning the details of case number 3061, the matter of Maravilla versus Maravilla. Mr. Alejandro Maravilla stood at one podium, his expression a mixture of fatigue and determination. Opposite him was his former wife, Ana Maravilla. They had once been a family bound by the sacred vows of marriage and the birth of their son, a boy who was now only 3 years old and soon to be 4. However, the warmth of that bond had long since cooled, replaced by the sterile language of divorce decrees and custody agreements. The judge began by establishing the facts of their current lives. She noted that they were divorced and shared a single child. When asked about custody, Alejandro confirmed that Ana held primary custody according to their agreement. The central conflict, however, had arisen during the very first exchange of their son for a scheduled weekend visit. Alejandro alleged that after a difficult enforcement of his visitation rights, Ana had intentionally keyed his car. The scene of the incident was described with vivid detail. Alejandro had arrived at Ana's home to pick up their little boy. In the driveway, a moment that should have been a simple transition for a child became a stage for adult turmoil. Alejandro explained that he had put the child into his car seat, but Ana insisted on taking him out one last time. Ana spoke with a voice that trembled with emotion. She explained that it was her first weekend away from her son, and the weight of the coming silence in her home made her heart ache. She had come out 5 minutes early, feeling a profound sadness. She wanted nothing more than to give her son a hug, to tell him that she loved him, and that it was okay to spend time with his father. She recounted how the boy had been crying, feeling the tension between his parents, and she wanted to soothe him. She had told the little boy that his daddy loved him, and that daddy needed time with him, just as mommy did. The judge listened intently, but spoke with the firm voice of experience. She reminded Ana that a 3-year-old child is incredibly sensitive to the emotions of his parents. To the judge, the act of removing a child from a car seat after he had already been settled was not an act of comfort, but one that created unnecessary hysteria and trauma for the toddler. The child needed stability and a calm transition, not a display of parental distress. As the narrative unfolded, Alejandro described a moment he heard a loud, scraping sound. He had allowed Ana 5 minutes with the boy, but as soon as she moved toward the vehicle, the sound of metal against metal echoed in the driveway. When he checked his car, he found a significant scratch on the door. The police were called to the scene. According to the records, Ana had initially told the officers she would pay for the damage, though in court, she claimed she had only said so because she felt intimidated by the presence of 20 police officers and the threat of criminal charges. The judge examined the evidence, including a video recorded at the scene. She watched the frames carefully, noting the movement of hands and the proximity to the vehicle. While Ana denied any intentional act, the judge pointed to the police report where Ana had admitted she might have accidentally scratched the door. The judge was firm. If damage is done, responsibility must follow. However, the conflict between the two did not end with a scratched car. Alejandro also sued for an alleged assault that occurred during a subsequent exchange. He described a day when he had parked across the street from Ana's home to maintain a respectful distance. He had brought a child support check, but he had written it out to her maiden name, Sanchez, instead of her married name, Maravilla. This small gesture, perhaps born of a desire for finality in the divorce, had sparked a fire. Ana had approached him aggressively, upset by the name on the check. Sensing the rising tension, Alejandro began to record the encounter with his phone. In response, Ana had reached out to grab the device. In the ensuing struggle, Alejandro claimed she had hit and scratched him. The judge watched the video of the second incident. She saw the check in hand, the movement of the bodies, and the clear aggression in the interaction. She spoke to Anna with a tone of stern education. She explained that no matter how irritated one might feel, no matter how much one dislikes being recorded in a public space, there is never a right to put one's hands on another person. Physical contact in anger is a line that must not be crossed. The judge observed that Anna seemed to view herself as a perpetual victim, directing her anger at Alejandro rather than finding a way to move forward for the sake of their son. In her final analysis of the Maravilla case, the judge dismissed Anna's counterclaim of false restraining order and awarded Alejandro $2,500 for the damages. Her parting words were a lesson in humanity. Parents must love their children more than they hate each other. Divorce is a difficult journey, but for the sake of the next generation, it must be traveled with dignity and respect. As the Maravillas departed, a new story began to unfold in the courtroom. Joy Mello stepped forward to face Mr. Larry Pilgrim, an attorney she had once hired to represent her son. Mrs. Mello was a woman of remarkable strength, a mother who had worked 3 jobs to pay for her son's legal defense during a trial that had ended in conviction for murder and a sentence of 50 years to life. Her claim was specific and born of a mother's meticulous care. She was suing Mr. Pilgrim for the cost of a suit worth approximately $700, which she had purchased for her son to wear during the trial. She believed that civilian clothes were essential for her son's dignity in the courtroom, providing him with a shield against the harsh image of a prison jumpsuit. She alleged that she had given the clothes to Mr. Pilgrim with the understanding that they would be returned to her once the trial concluded. Mr. Pilgrim, however, explained the reality of the court system. Once a defendant is convicted and taken from the courtroom, their personal belongings often disappear into the complex machinery of the sheriff's department or the coordinator's office. He maintained that he never took possession of the clothes for himself and had no knowledge of their current whereabouts. The judge looked at Mrs. Mello with a profound sense of empathy. She recognized a deep sadness that permeated the mother's heart. Mrs. Mello had lost her son to a long prison sentence, and the suit represented one of the last tangible ways she could care for him. The judge understood that when a tragedy of this magnitude occurs, the human mind often searches for a target for its grief. It is often easier to be angry about a lost suit than to face the overwhelming sorrow of a child's life lost to the legal system. The judge carefully reviewed a letter from the trial judge, which stated that the clothing had been returned to a coordinator's office by the sheriff's department. It was clear that Mr. Pilgrim was not the one holding the garments. The judge gently explained to Mrs. Mello that her anger was directed at the wrong person. The lawyer had served his role, and the disappearance of the clothes was a casualty of the system, not an act of negligence on his part. With a heavy but fair heart, the judge dismissed the case. She spoke of the nature of anger and sadness, noting that people often cling to anger because it feels more powerful than the vulnerability of grief. She encouraged Mrs. Mello to let go of the pursuit of the $700 and to focus on the reality of her family situation. The suit was gone, perhaps worn by another individual in need or donated to a charity, but its value could not replace the healing that Mrs. Mello truly needed. The courtroom fell silent as the proceedings came to an end. The 2 cases, though different in their details, shared a common thread of human struggle, the pain of transition, and the necessity of personal responsibility. The judge had provided more than just legal rulings. She had offered a mirror to the souls of those before her, showing them that the path to peace lies in respect, the control of one's emotions, and the prioritization of love over resentment. As the doors of the court closed, the lessons remained. The law is a structure of rules, but at its heart, it is a tool for teaching us how to live together with a measure of grace. Whether it is a scratch on a car or the loss of a suit, the true cost of conflict is always measured in the spirit. And in that hall of justice, the hope was that everyone who walked through those doors would leave a little wiser, a little more patient, and a little more committed to the well-being of the ones they love.